It's wonderful to see all of you here and to open the Democracy Institute's conference on excessive wealth concentration and democracy. I think the three things which are stated in the programmatic invitation are so self-evident that they hardly bear repeating. It's an unprecedented concentration of wealth, which we have seen over the last few years in almost every society in the world, that is part of the political polarization which is eroding in some ways the consensus around what were in Western liberal democracies, at least the consensus around the welfare state, which itself affects and has enormous implications for the social contract on which these democracies were based, is very clear. I come from India. In India, this consensus was the consensus that democracy was extraordinarily important, was never based either on social or on economic equality. So it's a very different trajectory in which democracy in India arises and democracy in India survives, with a great deal of polarization right from the beginning. So I think one of the things we might want to think about today is very different trajectories of democratization and how they tie in to different trajectories of societies and their ways of dealing with extremes of inequality, social inequality, and economic inequality. So what democracy provides is political equality, and it's always been in tension then with capitalism, which has a totally different logic. So it's not just about, in my view, excessive wealth concentration or the growing inequality, but it's also about a very fundamental tension between capitalism, whose logic is about economic growth, profits, and economists don't really care about the distribution in a way, or mainstream economics doesn't really care about how those are distributed. In fact, the mainstream view for a long time in the discipline has always been it's irrelevant how wealth is distributed, because the fact that there is economic growth will then lead to larger pie, which can then be distributed, but the distribution question has never been central. So equality is something, economic inequality, social equality is something which has never been at the center of the discipline of economics. So I think it's an interesting thing now that even some economists are beginning to realize that kleptocracies and what we in India have long called crony capitalism, which is not unknown to this country as well, are things which are highly detrimental and corrosive to democratic politics. So let me say just two or three things here which just struck me while looking at the program and looking at the kinds of questions that you would like to ask. The one question I have been asking myself a lot is about justifications of wealth, public justifications of wealth. Now, I'm by training an anthropologist and a sociologist, so I have a different take on this story. But I've been in long conversation with a very close friend of mine whose book has, I think, not been translated into English, but in German it's called Überreichtum, Martin Schulz. And Überreichtum is excessive wealth. It's the German translation of Plato's concept of excessive wealth, which Plato considered to be not healthy for a society, but also not virtuous for the individual. Now, with Martin, I've been talking about one problem, which I do want to pose here, because I think one of the things which is interesting is how differently excessive wealth is publicly narrativized and legitimized in different societies across the world. And I think the way in which it's legitimized makes a difference to how democratic politics is then confronted with this excess of wealth. So that's the sociological angle to the questions that you will be looking at. The other question I wanted to bring to your attention is the nexus between political power and the amassing of enormous wealth has in a way worked both ways, in the sense that liberalization, neoliberal globalization, privatization has helped amass a lot of wealth, and that wealth then has led to further deregulation and further privatization. So it's in a circular kind of system, which, however, has not been the same in every society. So one of the things I've been studying as an anthropologist on the ground are special economic zones. And these are very interesting zones of concentration for one particular reason. In a country like India, each one of the special economic zones are the private fiefdom of one particular capitalist or industrialist who has amassed special favors with the government, who's been done these favors. So it's a crony capitalist model which we have been seeing since a long time. But the global model, which Quinn Slobodian, for example, in Crack Up Capitalism discusses, is the global model has been little democracy in all of these little enclaves which have been built over the world, in which you want a special economic zone as your model for economic development. So, Singapore is a good example, Hong Kong is a good example, China, of course, etc. So I won't go into the details, but for me the interesting thing is this is not, and as Slobodian's new book, Hayek's Bastards, shows, we need to think about the ideological underpinnings of this entire enterprise, in which you have a very, very strong US-American ideological lobby pushing for a certain kind of capitalism, but it should function without democracy, and building those mostly so far outside of the US. So we need to take a very global view of the way in which a lot of experiments are currently being carried out in the world, in which there are enclaves of particular kinds of capitalism, which are then enclaves for non-democratic or anti-democratic practices. Now, the rich, of course, as all of you know, have much greater access to resources. They have much greater access to power, also to electoral politics, the way in which they influence elections. We've seen that particularly starkly in the US of late. But what we have also, I think, seen is that the more this dynamic continues, the less wealth in the state exchequer is there to distribute. So in a way, what it does is it corrodes the ability, it erodes the ability of the state to distribute welfare, further than weakening the basis for social democracies, especially in Europe, which was so dependent on the idea of state welfare as the backbone of that democracy. So I think there are very many different dynamics here, and let me end on just 2 points. One, that I think the preferences of the super rich, and we've seen that in the US very clearly, they just count for much more, and they have an oversized influence on the entire setting of the political agenda, and then, of course, its implementation in many ways. And my last point would be that excessive wealth never fell from heaven. It was an intended political process which brings about this excessive wealth. I've spent 40 years in India doing ethnographic fieldwork among the very poor, because it's impossible to do ethnographic fieldwork among the rich. They will not let you in to their companies, their homes, or their families. But what I have always pointed out is the corollary process is a process which is poverty also does not fall from heaven. It's a process of impoverishment, which is a politically intended process, which is the corollary or the parallel process of the amassing of excessive wealth. Now, in a country like India, the dynamics have been very interesting. You get that excessive wealth, you get enormous political equality, and you get a democracy in which 80% of the population goes to vote. The poorest cast their ballots, the rich stay at home. They've never participated in any election. So I look at this dynamic from a very particular Indian eye, of course, because of my own experience as a citizen, but also as a scholar. So I would really urge you to think of some of these big questions in a comparative perspective to get a sense of some of the nuances of the dynamics which we take for granted if we are basically looking at liberal democracies in the West, and especially the US, which is just so much in the news in all of these questions that we are addressing. So I'm very pleased to be here, very interested in learning a lot about the questions which I have been looking at from a very, very different angle, and a very warm welcome to you to CEU's original home. We were not established here in Budapest, we were established in Prague, but we moved very soon, also forced to move very soon, and were here at home for 3 decades. So this is our original home. This is the building which we refurbished a year before the Hungarian government forced us to move all our American accredited courses out of this, programs, teaching out of this country. We continue to hold the flagship of CEU High here through the Democracy Institute, which is at the heart of our research here on the Budapest site. And we have the Institute of Advanced Study, and we have the Open Society Archive. If you have time, please pay to visit. It's just around the corner. And I really thank both of you as organizers, Andrea and Andreas, and I'd like to thank Bruszt, who's been leading the Democracy Institute with great distinction since its very inception. So warm welcome, and I hope we're going to have an exciting intellectual adventure with one another.
Thank you, Shalini, for your kind words. My name is Laszlo Bruszt. I'm the director of Democracy Institute. Let me briefly just introduce to those of you who are from outside DI. That's how we call Democracy Institute, what we are, what we do. We were created 5 years ago in Budapest after the CEU and all its teaching programs were forced to leave Budapest. And we basically are in the front line of battle for re-establishing the rule of law and democracy. We do research. Primarily, this is a research institute. We have 5 great working groups that study democracy, democratization from different angles, based on partly cross-disciplinary and partly cross-regional comparative study. We have a big diversity of disciplines in and around DI. We have, among the founders, we had medievalists, historians, political scientists, sociologists, students of network science, gender studies, anthropology, and so on. So this is a very interesting mix. And as you see also in the program, this is reflected also in the way all researchers approach the questions linked to democracy and the rule of law. We have also lots of comparative and cross-regional studies. We just finished a 2-year program called Global Forum on Democracy and Development that had mobilized around 60 younger and not so young researchers all around the globe in 4 continents. And we do lots of research that are within the region. That's our strengths, of course. DI's most important strength is in the region, but we use this intimate knowledge of this region, the post-communist world, but also Europe, for being players in cross-regional studies. Besides research, we do several things that are linked to using the knowledge produced here. And when we are talking about knowledge produced here, of course, I refer to also our networks. We have a very lean organizational structure. We have on our payroll a limited number of researchers, but we work with in our programs and projects. We have over 200 people, researchers, scholars working with us, and so we use this knowledge also for participating in policy advice or advocacy. We are very proud of the Leadership Academy of the DI that teaches new generation of public leaders in Central Europe. We have several programs that are participating in advocacy, like the Rule of Law Clinic of the DI, or we are together with the European University Institute and Sciences Po, we are advising the Ukrainian government how to manage the governance of the European integration in a way not to fall in the trap several countries in the new member state fall, having 6-8 years after the joining of EU, Eurosceptic, illiberal governments in place. So we have several outreach programs like the István Bibó Free University or the Borderless Knowledge series of EU, and I can go on. So we have finally, what I definitely would like to mention, the Review of Democracy, or online platform that has over a dozen editors from 4 continents and allows for a forum for discussing issues linked to democracy. So I stop here in the introduction. Just briefly wanted to mention, actually linking to the ideas of Shalini, that we have been dealing with these questions of extreme wealth concentration, basically since the dawn of democracy in this region. So in the early phase of post-communist transformation, the central question in Eastern Europe was the relationship between democracy and capitalism, or to put it on the language of the 1990s, the simultaneous extension of property rights and citizenship, or political rights. That was seen by many as a problem. We even had the slogan of first perestroika and then glasnost. So first to have the extension of property rights and economic transformation, and it's too early to have at the same time simultaneously democracy. That was seen as a problem, and there was a fear by theorists of modernization or very interestingly, students of public choice, that the problem will be with the have-nots, not with the concentrated, those who have too much concentrated wealth, but those who have nothing. That is, they will use their political rights, newly acquired political rights, to take away the property of the newly rich, or prevent reforms and use the newly acquired political rights to even unmake democracy. So democracy was seen by them as part of a problem, and neoliberal economists or advisors to constitution making were suggesting either minimizing democracy, they were suggesting shock therapy, anesthetize the society before introducing the reforms, or using extreme concentration of constitutional power, executive power. They were suggesting basically strong super-presidential regimes that might solve the problems of this simultaneity. And then there was another group And several people here actually in this room were part of that, who said that democracy, instead of being part of the problem, is part of the solution. That what is needed, and that's the lesson, since basically the Federalist Papers or from late 19th century rule by rubber barons, for example, in the US, is that dispersion of power, dispersion of social, economic, and political power is the solution. That some of you might remember the piece of Joel Hellman on the winners take all, that the problem, the danger of the simultaneous extension is not coming from the poor or from the have-nots, it's coming from the winners. They might use the excessive concentration of economic wealth to capture the state and use that for corrupting both the market and the polity. And there were very good surveys and research that showed that on the one extreme are those countries that, at the advice of the researchers from the first group, introduced super presidential regimes, extreme concentration of political power. All of them were captured by the oligarchs. And the other extreme are those that had distributed not just political power, but also economic or social power. So now we have, 30 years after, somewhat different problems that in the background of this debate, already this neoliberal wave was on its way, resulting in extreme concentration of power in the global north and the global northwest. So, but that's the topic of this conference now. I would like to thank to all the organizers for bringing together this exciting program. It's really fantastic. I would like to thank especially to Andrea Krizsan and Andreas Schedler for bringing together an extremely interesting and illuminating group of speakers and researchers and putting together this exciting program. Thanks a lot. I wish you fun for the next 2 days and enjoy also your stay in Budapest if you have time.
All right, good morning. Welcome to everybody. Thanks for being here. I'm Andreas Schedler, the leader of the research group on de- and redemocratization. I think we have 2 minutes left officially to go to the keynote speech. So let me basically scrap my notes and say probably just 2-3 words. First of all, in our debates on the global crisis of democracy, we have all been very much focusing on kind of the bad guys, you know, those who threaten democracy, the enemies of democracy, and we have paid very little attention to the structural threats of democracy. And I think all of us who are gathered today, I guess we agree in that the enormous concentration of wealth in private hands today is really a structural threat to democracy. It really runs against the basic egalitarian promise of democracy. 2 notes. On the thanks from Laszlo, I would really extend them to everybody, to the panel organizer. This was really a collaborative, decentralized effort. To Andrea, it was the ideal collaborative venture. It couldn't have been better. To our splendid organizational team, headed by Ruth, to our leadership, to everybody, to you who are here. So this is really a Democracy Institute venture. Let me just say one small thing that may be on everybody's mind in some way, that surely you think it's kind of a weird thing or a strange thing for us who are dependent on the generosity of one hyper-wealth family or individual in the Open Society Foundations, George Soros, to talk on and talk critically, analyze critically the hyper-concentration of wealth in individuals. I think all of us, the CEU, the Democracy Institute, George Soros, the Open Society Foundation, we have to accept that tension. I don't think that George or Alexander, his son, they know that we are gathered today to talk about the hyper-concentration of wealth. I'm sure if they knew, they would be pleased. So that's all I will say for now. Andrea, the stage is yours.
Hello, everybody. My name is Andrea Krizsan, and I'm the other organizer with Andreas, and thanks go the other way too. So we were a very good team together with the DI team. I'm not going to scrap my notes because they're very short, so I want to say the points also because they feed into the main debates, discussion that we're going to have. It is about the tension, a critical tension that we have here. It's important. I'm leading the Democracy, Inequalities and Democracy Working Group within the Democracy Institute. And I think it's important when we had this title up there and we figured it out, everybody's first thinking of inequalities in economic terms. And it's important to know that our working group on inequalities works on economic inequalities too, but it has a lot of focus on status-based, on social inequalities, on gender, on race, on religion, on disability, and these are critical issues, and I think it's important to see the extreme concentration of wealth also from that angle, and maybe it is a little bit different, not so much different, but it's a good way to look at the tensions that are here. And I want to, on the one hand, show how the hyper-rich are key protagonists in funding actors that are key to hate-mongering. It is think tanks, it is political parties, it is civil society actors who are fundamentally undermining equality and working towards an exclusionary notion of political life, towards an exclusionary political project. We have plenty of data showing how hyper-rich are financing some of these platforms, that they are putting money into these platforms, and that is important to see as one aspect. But I think it's also very important to see the other part of today's current world, which is where a third wave autocracy is spreading, and we see states that are captured by actors who are against critical voices, against critical civil society, against advocates for human rights, advocates for racial equality, for gender equality, for LGBTQ rights. And these states are increasingly either shrinking funding and space for these organizations, or are actually excluding them altogether from funding or from allowing them voice. And in this picture, maybe the hyper-rich gain another role. I mean, we really have to see how the hyper-rich are critical to funding such initiatives. They come in and complement faulty states, biased states, captured states, and this becomes really a tension. So sometimes that funding comes with strings, many times it comes with strings, but many times it is these funding patterns that are encouraging more participatory, more inclusionary ways of distributing money and rethinking how we can have more inclusionary democratic constituencies. So in that context, in a way, the hyper-rich also are a potential, and if you look at the United States and the discussions that are going on there about what are the potentials for stopping autocratization, then you will also see how the number of hyper-rich who can actually finance actors that are standing up against autocratization becomes an asset for the United States. So that's how many democracy scholars actually speak about hyper-rich there. So clearly there is a tension, and I'm not going to solve this here. I just want to say that we meant this conference to be a platform where we can discuss some of these tensions and see what are the bottlenecks to extreme concentration of wealth, and maybe what is some of the potential and the way forward here. So thank you so much. Welcome to Budapest. Welcome to the conference. We look forward to some interesting and thought-provoking discussions. Thank you.
Thank you, everyone. I'd like to introduce our first keynote speaker, Katharina Pistor, who is a professor at Columbia University.
Okay, sorry for this tiny glitch. We could do two things in the meantime. Either I could recover my notes, my previous notes, or I could start introducing Katharina, even while she may not be listening, but it's you who is the audience, so I may very well do that. So even if her attention is elsewhere, it's a real pleasure to introduce to you Professor Katharina Pistor. She's professor of law of comparative law at Columbia Law School. She's a leading scholar in global debates on inequality of wealth. She's, I would say, a rock star in these debates. She may not smash too many guitars today, but she's really someone, you may have read pieces by her, you may have heard about her, but you may not know everything about her. So you may not know that she obtained her law degree from Freiburg University in the late 80s, then went on to get an MA in law from the University of London, specializing in Soviet law and Chinese law, a master in public administration at Harvard later on, and then a doctorate in law from Munich University, all that in 1 decade. And then at the beginning of this millennium, she moved to Columbia. Since then, since kind of looking back over a quarter of a century, she has really delivered an impressive work in what I would describe the international political economy of law. So she has published in countless journals of law, of the social sciences, has written, co-authored, edited almost 10 books, and she is about to publish two further books who are in the pipeline. In recognition of her really impressive achievements, she has been elected member of the Berlin-Brandenburg Academy of Sciences and Humanities, of the European Academy of Sciences and the Club of Rome. All right, so I continue with my notes while this is kind of the preview. For those of you who do not know Professor Pistor, you may be asking, why should we open a conference on wealth and inequality with someone who teaches US corporate law to elite students in New York, who then will go on to just oil the wheels of capitalism? Sounds strange, isn't it? Doesn't it? But I think much of the answer, or at least kind of the most influential and well-known answer, lies in her book, The Code of Capital. How the law creates wealth and equality. Widely kind of successful and cited book. Before reading that book, I thought that I had understood the basics of capitalism. I thought I knew how capitalism worked. But really, Katharina showed me that I had failed to explain, to understand and to see the basic creative role of lawyers, of private lawyers, in crafting the legal infrastructure of capital. As Katharina Pistor argues in the Code of Capital, in that book, with really admirable erudition and lucidity, in an empirical analysis that spans centuries, the whole globe, and disciplines, and various disciplines. So in this book, she shows that lawyers, the masters of the code, as she calls them, have been kind of the big omitted variable in our comprehension of capital, in the history of capital. So again and again, these lawyers have been creating and recreating the legal foundations of capital. They have been crafting complex bundles of protective rules and protective exceptions, and they have managed to get these rules recognized and protected by national states all across the world. A really big feat. And And in our discussions on democracy, in political science and outside, we usually stress the intrinsic, intimate connection between democracy and the rule of law. And the current debates about democratic backsliding and the subversion of democracy, we always jump in and defend the rule of law. That's kind of the almost our first line of defense. And when doing so, we tend to overlook really to the extent that law, how much of our law is neither democratic in origin nor in content. And the Code of Capital, Katharina's book, really shows how much of the law that creates and protects capital, the empire of law through which capital rules, as she formulates, is neither crafted nor sanctioned nor controlled through democratic institutions and procedures. It's really the work of lawyers, not of legislators, not of courts, not of national sovereign states. So Karl Marx famously thought that the economy was the basis of society and the rest was superstructure. With her work on the legal foundations, the legal infrastructure of capitalism, Katharina draws our attention to what we might call the basis of the basis. So Katharina, thanks a lot for being here, and the stage is yours.
Thank you so much, and thank you for your patience. I just want to say that I'm really delighted to be back at the CEU. I was there in the early days in Prague. I was researching privatization in Eastern Europe and Russia at the time. And as my colleague Mark Mazauer, a historian, said when I wrote the Code of Capital, I could have never written that book had I not had the experience of looking at socialist countries trying to make what they called a transition was a transformation into a different regime, because you really had to unpack the institutional structures, both of the countries that you looked at that were trying to change and the countries where they supposedly were going. And much of the policy advice that came out of economics did not have any sense of either. They didn't even understand their own capitalist systems, much less the socialist regimes. So I'm not going to talk about socialism, although I will mention a couple of the early socialist legal theorists, which I think had deep insights into what capitalist law looks like. Brief outline, I will talk about capitalism as a legal regime. A new book is coming out which is called The Law of Capitalism and How to Transform It. So if the Code of Capital unpacks the very institutional, micro-institutional structures, what I like to call the legal modules, and the attributes that capital has in law, the next book is trying to say, well, how does it work at a systemic level, and what does it mean for the reconstitution of capitalism and potentially for its transformation. So I will try to merge both of these ideas in my presentation today. So capitalism is a legal regime, first point. Second, I will talk about the foundations of capitalist law, about the relationship between capitalist law and private power. And then I will make the core point is that inequality is legal. It's built into our legal systems. It's related to resources, but the resources themselves owe a lot to the legal structures. And then I will just hint at some ideas I have about transforming capitalism through law. So capitalism is a legal regime. It's basically, I like to define capitalism as a system that uses a social resource, the legal system, to create private wealth by monetizing today expected future returns. And this time transformation, saying I have expected future returns, I can monetize them today, for example, by trading an asset, is made possible through law. It doesn't exist without having titles, without clarifying the different rights the different parties might have to the same asset. It doesn't happen without giving them some protection against loss of value, and certainly not without having a state saying, we back these structures. So it takes not just a village, it takes a state, and it takes a legal money system to create capitalism as a legal regime. So what are the foundations of capitalist law? One idea that I did take from Yevgeny Pashukanis, who wrote in the 1920s, he was one of the leading socialist legal theories of his time, was later executed by Stalin because he insisted that the state and the law should wither away in a post-socialist society on the way to communism. But he basically wrote, although his book is about socialist law, it really was a fundamental critique of capitalist law. And he says one of the fundamental distinctions of capitalist law is the separation of public and private. He calls it not only the duality of public and private law, but the antithesis of public and private law. And while many legal theorists and other legal realists and other realists have said, in the end, all law is public because it must be enforced by the state to be legally valid, Pashukanis actually wrote much earlier that you could also say that in the end, all law is private because that's where it comes from. If you trace it back to Roman law, it's private and then backed by the state at some point, but these are the roots, and I think this is important. The second important point about the foundations of capitalist law is that capitalism, historically in the West, preceded democracy. So this is another variation on the theme that Laszlo was talking about. What is the relationship between capitalism and democracy? The American historian Jonathan Levy, in his book Ages of American Capitalism, writes in one opening paragraph of a chapter, just almost in nonchalant fashion, he says, capitalism was there first and then came democracy. So the question is why capitalism ever tolerated, perhaps even needed democracy, and whether it's ready to discard it is something I think that should be on our mind. And then the third foundation of capitalist law is that there's a very strong preference for private self-ordering as opposed to collective self-ordering. Private self-ordering is not only necessarily individual, it can include contracts, but the idea is that individuals order their affairs themselves without the state intruding, whereas in fact, as I will show, they can't do much without actually the state, because if you want to have an enforceable contract, it has to fit the requirements of a contract, and you have to have standing in court, etc. So the state and its law is always in there, certainly in the modern legal systems. So the theme that I will come to back again and again is basically what is the relationship between capitalist law and private power. And I see this as a dynamic relationship. It's not just unidirectional, it's not just monocausal. So I will start with private law and go back a little bit to the Code of Capital and explain to you the core ideas of the code. I will then sort of move on to public law, which is the body of law that we typically use to rein in the excesses of capitalism that are validated by private law. So we're trying to curtail through financial regulation, sometimes through taxation, through limits of what you can do. Also, the entire court system can be thought of as public here. So standing in a court of law is important. That's all public law. And then, however, because of particular features of capitalist law, we will see that somehow they always get around these restrictions and are always able to reconstitute their own priorities, their own demands on society through legal means. This is important. For capitalism, it's absolutely critical that what they do is legal, because that gives them the ability to harken back to state power and say, well, it's legal, to necessarily enforce it in a court of law, even to engage in strategic litigation to advance their interests. And that together is really the source of private power. It's private wealth creation through law. It's private autonomy guaranteed by law against others, against other private parties, but also against the state, and a complete lack of accountability vis-à-vis those that are subordinated in this process. So when you think about the mechanisms to control private legal arrangements, typically competition law, some regulation, but the foundations of private law are not among them. And so the mechanisms of accountability that we have developed for state power are largely absent in the case of private power. So this is just the cover of the Code of Capital. The core argument I made in the Code of Capital is that capital is coded in law. I said now also capitalism is a legal regime and the two are related, but capital is basically, this is the micro-institutional level, and the capitalism story is the system level. So I'm basically saying, give me any object, a piece of land, any promise, payment in the future, or any idea, a new invention, new writing, something like that. And with the right legal coding, I can turn this thing into a wealth-generating and wealth-protecting asset, and that's a capital asset. So capital then is defined as a wealth-generating assets, and law is, by and large, the institutionalized means of coercion. That's what Max Weber and others have associated with the state. So you need some basic assets, but a piece of land is just a piece of dirt. You can graze your cattle, you can go and have a picnic, you can jog on the land. You cannot monetize the land unless you have legal title. You cannot sell it, you cannot mortgage it. You can't do anything with the land other than using it, and that can be very valuable, but you can't monetize this gain without legal protection. That's the core point, and the same is true for promises and for ideas and other things as well. So the legal modules I identify in the Code of Capital are the fundamental institutions of private law. Property law, collateral law is part of property law, especially to secure an asset like a mortgage. Trust is a common law invention, is quite important because it is so flexible and can shift property rights without really shifting property rights in law. Corporate law is another important module, bankruptcy law and contract law, which can mimic most of the features of the other areas of the law. So I'm not going to bore you with that. Unless you're a legal nerd, you might not be interested in all these institutional details, but if you have a bit more interest, I try to explain them in relatively accessible terms, but it's all relative in the Code of Capital. So I won't say much about this. You can ask me later. The question then is, what do these legal institutions do with our piece of land, with our promise, with our invention? And what I'm basically saying, what the law does, it creates certain attributes of capital, and these are critical to defend against others, they are critical to create wealth. The first really is universality, and that's basically saying it's legal. If it's legal, the state can be mobilized so that it will protect these rights against the world. This is not only an arrangement between you and your neighbor, you and your friend, you and your transactional party. It's an arrangement that always has this third aspect built into it. If somebody else comes and says, I haven't heard about this, I wasn't at the table when the arrangement was made, you can say, but this is an arrangement that is protected by law, and we will defend this arrangement against you. And if it's legal, that's what you can do. That's critical. So universality basically says it's legal. Priority suggests that the legal system actually ranks different types of rights all the time, which is kind of important because this also means we don't have to run to court all the time when we have a dispute about what's your right, what's my right. So think about somebody, like a friend of yours who might face insolvency, and you have just lent your car to that friend. It's your car, you have your title, the car is in his possession. His other creditors, maybe the banks, to whom he might have mortgaged the house, they're trying to find all the assets that are now available to meet their claims. What happens with this car? To whom does the car belong? Since you have property rights, and that's the highest right, you can pull out the car from the pool of assets in bankruptcy, and all other creditors have to stand aside and have to accept this. They have to satisfy their claim from the rest of the assets that are left. So if you have priority, you're always better off. Property is the most powerful right, priority right. But if you use your property right to mortgage your house or to use your car as a collateral for a loan, your creditors can take it away. So expropriation comes not only from the state, it also can come from your private neighbors. Durability. Durability means that you can protect an asset or pool of assets against too many different claimants who want to put their hands onto these assets. And the best example, of course, is for example, the state wants to tax certain assets. If you can create a legal pool and transfer this legal pool to Luxembourg or the Cayman Islands and can make a good case that this is legally separate from you, you can avoid these taxes and not evade, because you have created a legal structure that is acceptable in law and that will be enforceable in law, and so the state cannot tax this pool of assets that are now in the jurisdiction of Cayman Island. Durability is created through trust law, also through corporate law and other organizational law devices. And then last but not least, for financial assets, durability is less important because you trade them all the time. But financial assets can attain durability if they can be converted or flipped into a safer asset in times of crisis. So in times of crisis, most private assets lose value. And we always talk about the investors are heading for the exit. Where are they heading to? What do they want when they head to the exit? They want state-issued money, not private-issued money, if you want to say all these financial instruments are a form of money. Why state-issued money? Because only state-issued money can protect its nominal value, not always real value. We have inflation, of course, but the nominal value, a dollar is a dollar is a dollar, a florin is a florin is a florin, a euro is a euro is a euro, and you can pay your taxes with this money without any discounts, without any haircuts, is absolutely critical in times of crisis. Effectively, when you flip your bonds, your shares, your derivatives, whatever you're trading into state money, you basically cash in the expected future returns today. You're parking your past gains until financial markets have calmed down, and then you do the game again. So it basically creates a bottom insurance device against the volatility of financial markets. So these are the critical attributes that these modules, which are old, you can trace most of them to Roman law, the trust to the 12th century, maybe corporate law is a little bit of more recent origin, but you can use these modules which have been in principle around for at least 400 years, and they have been used to package capital, land, firms, debt, even data, you name it, I'll tell you how it's being coded. Okay, so let me get this a little closer. So second step. When capitalism goes overboard, and the clearest sign for these are financial crises. Think about the 2007-2008 crisis. Think about the East Asian financial crisis of the 1990s, and they affected, of course, also many socialist countries, former socialist countries. Russia had a deep crisis in '98, and other countries were affected by that as well. When we have a crisis, we realize that many capitalists have probably tried to code too much capital, and they then realize that they won't find so many takers for the stuff that they had created, so they can't preserve the value or increase the value through trading in the market where people will bid up the prices. They will basically go back home to mother, if you want, to their own state and say, give me cash. Give me cash. And if they have cash, then they're safe, and then they can continue this. Most societies realize at this point that they need to regulate somehow, to curtail the ability of capital to play this game. And so we have, in moments of fundamental crisis in the United States, the New Deal of the 1930s is the best example, but you could also say the post-war legal order was created in deep recognition that, yes, there was fascism in Italy and Germany and other countries, there was the Holocaust, there was the war, but there also had been a deep economic and financial crisis. So you reorder the world quite consciously by saying we will curtail capital flows, we will pack the dollar to gold, all other currencies to the dollar, we will restrict, as I said, capital controls, and every country will try to find the right balance between the public law and the private law. Well, what happens then is typically that it takes only a while for the users of the private law, the clients and their sophisticated attorney, to wiggle around the legal constraints that are being put in place. So public regulation is an antidote to the coding of capital, works usually for a while. When I talk to the lawyers in the city of New York, they typically tell me it's just a question of time after the next round of regulation for us to mute, to effectively make ineffective the intention of the regulation that has put in place. You just have to find new coding techniques to get around it. So one of the problems of the regulation is also constitutional. The constitutional democracies would tell regulators they have only limited power. They can't do what they want. They get certain delegated power, and if they overstep that power, whatever they do might be struck down. A constant struggle in the United States. Legislatures can delegate to regulators, but they don't have limitless power to do so. Legislators should be the ones who make the law. And of course, then many regulators have very, very important resource constraints, because how much resources they have in order to police the market as they evolve again post-crisis is really critical for seeing how effective they are. So the long-term effect, as I said before, is through legal arbitrage. I will say more about this in a second. The constraints that are put in place by regulation are time and again weakened, relaxed, if not made ineffective. So examples in the post-war order, we had capital controls, we have financial regulation, we had a social market economy, we have the expansion of rights for women and minorities, we have had new guarantees for access to justice, changes in the Civil Procedure Code. Most of them have been reversed. We have, of course, the full free capital controls, we have deregulation, we have the expansion of private autonomy, we have financialization of almost anything, and we have the privatization of law enforcement through arbitration. Then we were hit by another major crisis in 2007, 2008. Lots of meetings, lots of efforts by the Financial Stability Board and others, a new regulatory regime, etc., skin in the game, spin-off of trading desk. So in the immediate time after the crisis, there were a lot of discussions about this. And then, in fact, most of the reforms were never fully implemented or relaxed. The first Trump administration already curtailed some of the stress tests and financial regulation for banks. So this is the same game. It can happen through just coding strategies, through private law. It can also happen through massive lobbying, and of course with the right alignment of political parties in power, that will be pushed back as well. Okay, so now I'm basically moving from public law to private law just to show you again what are the mechanisms, how is the law constructed to allow private actors, to allow the capitalists and their lawyers to get around the legal constraints that basically democratically elected legislators are trying to put in place to curtail capitalism, to make it sure that everybody has a piece of the pie. So the features of capitalist law at a systemic level, I argue, are first private empowerment. We do empower through law private parties to take the law into their own hands and organize their affairs with one another in law themselves without having to ask for approval. All they face is ex post scrutiny if somebody takes them to court, a private party, or maybe a regulator. We very often, as I mentioned before, Max Weber and others have said, is the state is the embodiment of the centralized means of coercion, but access to the centralized means of coercion is highly decentralized. It works through litigation. And if you have a lot of resources and you might face a lot of legal problems, but the law has to work your way to create wealth and inequality for others, then you very often litigate not only for the outcome of a particular case, as Mark Gallanter already said in the 1970s, you are in the game for the rules. You litigate strategically to change rules that in the long term help your business model. And once you have a precedent in the common law system, that's easier to attain than in a civil law system. But once you have a precedent, you basically have won the game. And if you are afraid that the judge might not issue the precedent that you want, then you do a private settlement. Then you just put a lot of money on the table and say, let's just settle out of court. Because the fear that a court case might go against those who are trying to litigate strategically is simply too big. And then last but not least, legal arbitrage. And let me just say a little bit on each of these points. And Laszlo, you tell me when I'm out of time, so I will rush a little. So private empowerment, I mentioned property rights already. By saying individuals have property rights that they can defend against other private parties, but also against the state, you empower them quite significantly, because even the state cannot curtail your property rights easily without facing constitutional constraints and perhaps the need to expropriate, to pay expropriation compensation to you. The private law in capitalist societies operates on the assumption that all are formally equal before the law. That's quite different from saying you're substantively equal. You're formally equal before the law. Proudhon already said early in the 19th century, we all have the same right to sleep under the bridges. Of course, we all have that right. But formal equality and not substantive equality, of course, means that you can play the game of the law with the resources that you have. Nobody will look through the resources. When you think about our online world, you click agree because the GDPR wants you to click agree. But this agree is a contract. You enter into contracts. You have never read most of the fine print, I assume, because if you did, you would spend like 7 months per year reading the fine prints of the contracts that you're signing every day. This is no longer the contract that the Roman lawyers were thinking about, or the contracts that we idealize as a mutually beneficial instrument between two private parties. This is a standard contract that the suppliers of that contract give you, and you have a take it or leave it option. Sign it or don't sign it. There's nothing to negotiate. You can negotiate contracts if you sell your used car on the market. Everything else is basically set by boilerplate contracts that are controlled by one party. So the illusion of formality, formal equality, and contractual consensus basically locks us in a system in which we are actually dependent and can have no options except to say yes or no. The other thing with formal equality, as you also, I'm sure, are aware of, we are all sort of just normal human beings, humans, but we're also legal persons in the civil code. The French civil code first coined this framework that upon birth you become a legal subject, and with it you have certain rights. You can own property, your parents might have to manage it, but you can own property. With your guardians, you can enter into contracts. You have certain rights that are basically given to you by a legal system. But in addition to us natural persons, we also have a lot of legal persons which are actually dominating our economies. They're called corporations, multinational corporations. Corporations are juridical persons. And this means that they can own their own assets, they can contract in their own name, they can sue and be sued in their own name. They act as you and me for the purpose of economic interactions, and they have an infinite lifespan. They don't die unless they go into bankruptcy. So this gives them a comparative advantage over us, which is enormous. And then, of course, they can also shift some of their own resources into a subsidiary, which they can control, which is a separate legal entity, is again formally separate from you, is equal in many different ways. And so the parent was trying to avoid liability for whatever the subsidiary does. So lots of legal constructions here to create private power. I mentioned formal consent, so I don't have to go back to this. The second important feature or characteristic of capitalist law is decentralized access to the means of coercion through litigation. But who has access and on what grounds is really critical. You as a legal subject can sue, but there are also rules where you have to go and sue if you have somebody on the other side. You have to typically sue the defendant in where the defendant is localized, so where it's incorporated, for example, so it puts you into a different position. And not all rights are justiciable. Mostly we allow individuals to fight for individual rights, including the individual rights of corporations. We're much weaker in protecting collective rights, cooperatives and other legal structures in this fashion. And then, of course, you can also face the problem that you might not have access to the courts. Most civil courts in most countries, developed countries today, are completely overburdened. It takes years and years and years to get access to justice. And as Weber already said, if justice delayed is justice denied. So the system doesn't work equally for everyone. On top of that, especially in the United States, in Europe, especially in consumer law in Europe, there are more protections. But in the United States, a lot of contracts are being shifted into arbitration through mandatory arbitration clauses in the contracts that you never read. So even employment contracts have mandatory arbitration clauses that also deny workers collective actions that are otherwise available in the United States or other procedural devices. So the contractual mechanism is used to disempower others, typically the weaker, structurally weaker parties, and to empower the structurally more powerful party. And then last but not least, legal arbitrage. This is really the means by which entities, individual actors that are being regulated can get around the regulation. It starts with something that you cannot eliminate. Law is inherently incomplete. Those of you who study economics and contract theory and economics know that all contracts are necessarily incomplete because the contracting parties are unable to foresee all future contingencies. So basically fundamental uncertainty, we can't write everything in a contract. Then if that's true, then it certainly is also true for law, because law is meant to apply to many more different circumstances, many more different people, and into the indefinite future. So law tends to be relatively general, which means also that we can use the gaps in the law or its generality to interpret it in all kinds of different ways. And if I'm a transactional lawyer, I will take advantage of this by featuring transactions or by creating transactions that are in favor of my client. They take advantage of the incompleteness of the law. They absolutely make sure that you do not violate the law. On top of that, of course, we have multiple legal orders laying on top of one another. There's municipal law, there's state law, there's federal law, there's European law. There are different legal systems that apply to similar transactions. We have transnational transactions or corporations. They usually invoke multiple legal systems. If you can play that game really well, including for taxes, you have a comparative advantage. On top of that, most legal systems have what we call choice of law rules, or private international law in the continental use of the word, which basically means that the legal systems say if more than our own legal systems, 2 or more legal systems might be in play for a dispute. Let's say you went on vacation to Italy and you were hit by a French driver. You return to Hungary. Under what law will you now try to get compensation from the French driver? French law, Italian law, Hungarian law, where do you sue? That's the stuff that is handled by choice of law rules. For transactional purposes, you can take advantage of that. If you know that English common law or New York law is very friendly to financial transactions, you make sure that you can choose that law for your transactions. And then they govern even if the financial asset is being traded in Europe. So we have, as a result of that, not like clearly defined boundaries, territorial control of the state, which is our image of our state constitutions and our territorial states, really. But you have basically networks of contractual relations that are anchored very often either in London or in New York. Same with choice of forum. You can choose the court where you wish to litigate. Okay. So final point, the relationship of all this to private power. As I said at the outset, inequality is not a bug of the system. It's a feature. It's legal. It's legally structured. And that's basically what Pashukanis already captured when he said there is a duality or antithesis, an inherent antithesis in public and private law built into our legal systems. You get legal protection for private wealth that you create with the help of lawyers that you pay like $750 at least for by the hour, if not much more nowadays in New York, so you have to have the resource to even go down this. Same for taxation. You can avoid taxes easily. You need lawyers, you need to be able to afford it. Rule of thumb, have $50 million at that level. It really makes sense to do this. State capacity is being reduced in part because tax competition among states makes states less powerful in using their own resources to counter this. And of course, there is competition which is enabled by conflict of law rules. Last but not least, as I said before, there's no accountability of those who are subjected to this regime to those who are using it to their own advantage. Because you consented to most of what's happening here. You signed, you clicked agree, you signed the contracts. You consented to a regime that subordinates your interests to those of the capitalist. Okay, 2 more slides and I'm done. Of course, many have already raised questions of how we could overcome capitalism. Marx mostly thinking about class struggle and revolution. Andre Gunnar Frank wrote in the late 1960s about dependency theory and basically said this is really a structural relationship between the periphery and the center, and disregarded institutions largely as explanatory power for these structural differences. If you followed my talk, you would not be surprised to hear that I think actually the institutions create structures that make it hard to overcome the difference between the center and the periphery. Wolfgang Streeck, who was long a director at the Max Planck Institute in Cologne, he basically talked about the end of capitalism, how it might happen, and describes an endogenous decline and a kind of interregnum from which something new might emerge. We don't really know what. And then last but not least, John Padgett, a sociologist who has studied complex social systems in Renaissance Italy, in the Netherlands at the cusp of the emergence of the capitalist system and others, and has used large data sets to do so. He actually has argued that transformation happens typically when societies transform different domains of their social structures simultaneously in similar direction. So the Netherlands, for example, became capitalist after it freed itself from the reign of the Catholic monarch from Spain. They had basically, they transitioned in a period of 50 years, not that long. In that time, you have not even powerful information systems. They transitioned to a system that was decentralized in the churches, the new Calvinist churches, That was decentralized in the organization of the state. The general estates came about as a federal structure, and that was decentralized in commerce, although it also gave birth to the corporation as a now very powerful new business entity. I find Paget's description of these transformative changes very illuminating, and that's how I want to think a little bit about the transformation of capitalist law. So if capitalism is a legal regime, then it has to be transformed through law. You can't do it outside the law. That's sort of one of the dilemmas, the paradoxes, if you want, of this kind of argument, because the law creates everything. We wished we could just get rid of it. But for complex systems, we need some set of rules for how they're being governed. So we have to think about how to get out of what we have and into something different. So a lot of literature, including Paget's work, but also Catherine Taylor and others, have actually shown that transformative change can happen through a lot of incremental change, whether or not you also change the formal rules. Legal arbitrage on the capitalist side is one strategy, but you could also have legal arbitrage on the other side. You have to think about how to get the resources and the legal knowledge to do so. You can exploit, just as the capitalists have done, gaps and openings in existing law and reinterpret existing law. One could add, and that's an idea that I pursue in my new book as well, it's an idea by Martin Hesselink, who suggests that we should write like a just private law code, at least for Europe, but maybe for the world, that brings in some of the ideas that private law too should be based on the fundamental normative foundations on which we base our constitutions. It should not be able to basically dislodge itself from constitutional values and do its own thing based on private power. It should be subject to the same things. In order to enable this change, I think we do need some institutional structures. We need more collective standing in a court of law. We might need more citizens' council to adjudicate certain things. We certainly need stronger legislators as well. The common denominator, I think, would be the shared goals to make private law democratic as well. Thank you very much.
We have 3 mics. Does it work? I don't know. Thanks a lot, Katharina, for a very wide-ranging talk. I have a lot of questions myself, but I guess we should grasp the opportunity for opening the debate right away. We have quite some time. So yeah, please let's start collecting a few questions and then come back to you. Please.
Thank you so much for your talk. I had 2 questions. I wanted to ask you, like, how does your argument change when, or like, what do you think about with the rise of right-wing religious nationalism? How does this change, and does it make any difference? And you seem to talk about structural and institutional change that comes with collective solidarity action. And I wanted to ask you if there is a role of individual, where is the individual there, and if that could make any change in that. Yeah, thank you.
Probably we can collect a bit with all that light here. It feels a bit like an interrogation, right? Probably before other hands go up, I would have a personal request to you in the sense that you didn't much emphasize that part of the kind of the creative part of the lawyers. And kind of one thing I found very revealing when reading your book is that I have been kind of grown up and lived in a civil rights tradition. And like many of us, I guess, from a European background. And kind of the importance of lawyers and their creativity and their kind of all these margins they have kind of to invent practices, to go along, and then to argue in terms of, well, this is similar, no, this is different, and see how they get at some point recognition by judges without having to go through the processes we have it in mind, first you create laws and then you adjudicate, etc. So this is something I would like you to explain to us. I think it's very revealing, and you just mentioned it in passing, so I think that's an important thing. Any other? Yeah, in the penultimate row, please. Yes.
Hi.
Okay,
Hello.
Marlies, I think. Yes, if I
Yeah,
see you right.
yeah.
Marlies, please, go ahead.
Thanks. I really enjoyed, found your lecture very interesting. I just had a couple of issues or questions which you might want to address. I guess one is, and that's probably true of the introductory remarks that several people made, but you alluded in your talk to sort of the idea of revolution as a challenge to capitalist law. But I just wonder whether, short of revolution, you know, mass resistance, what role does mass resistance play to the implementation of certain kinds of laws and legal rights that property and property owners might enjoy? And how does that help to transform law in itself, because it creates a different context? The second one was, you said in one of your slides, you pointed out that capitalism preceded democracy, but I just wondered if you might want to say something about the fact that liberalism also preceded democracy by some time. And the third one was picking up your point about lawyers as intellectuals, as makers of history and perhaps even remakers of it. And I just wondered if you might want to comment on that too. Thanks.
Let's take one more now. Marlies, please. Yes.
Thank you very much for your talk. I actually have a question that you might not be able to answer, but I'll give it a try. I would really like to better understand in the relationship between corporate boards, corporate CEOs or individual billionaires and legal teams or large law firms, the legal expertise. Who is kind of driving the litigation or the lobbying for regulation? Do you think it's primarily coming from the economic power holders who are saying this is what we need to achieve, go and find us a solution? Or do you think it's the lawyers who are actually coming with the solutions and the workaround and kind of give a menu and the economic power holders go along with whatever menu is on offer? And I realize that a lot of that is not actually subject to observation, but I would love to hear more of your perspective on that.
Okay, now the floor back to you. Please.
Okay, thank you for these questions. So let me start with religious populism or religious movements. I don't want to fall into the trap that everything that happens to capital is like a response to it. It's just a reaction to it. But that sort of, I think one could at least make that point that people are mobilizing, organizing themselves against a system over which they have no longer control. So I think much of populism of different stripes strikes me as a response, as a gut feeling that you don't know, you might be told that you're living in a democracy, but you do not have control over the future of the system. You vote this, nothing happens. You vote that, nothing happens, right? And so you vote extremes to see what happens, and you organize with people that have some shared ideas against a regime that you don't control and that subordinates you in a certain way. So I think that would be my first cut reading on this. Where's the individual in this? So I think what is ironic to me in the capitalist literature and also in the neoliberal discourse is that the ideas of individual liberties, some of them, of course, the ideas to them precede democracy, absolutely right, are being abused as defenses for large corporations that are bureaucracies in their own rights to defend their rights against others. And you don't have to live in the United States to see this, but in the United States it's extreme because corporations also have free speech rights. So if you put money into party campaigns, political party campaigns, that's declared free speech. So you can fund by the millions, and that's kind of legal. So the individual like us, like the natural person behind that is a small little particle in a system that deals with legal subjectivity. And individuals also have legal rights, but we're all formally equal before the law. The resources differences and bargaining power difference abstracted away from. That makes us so minuscule, so small, so ineffective in this particular system. On your questions, where are the lawyers and the master of the code? So yes, I think the master of the code are important. I talked today in slightly more abstract fashion. So when the law is incomplete, when there are frictions between legal systems or legal rules. When there are lots of opportunities for legal arbitrage, that's where the lawyers come in. Right? That's how you exploit the difference between these different legal rules that you have. And I can maybe also link this to your question. What is the role of the lawyers? An independent legal profession was something to be really proud of. It first emerged in England, on the continent, both in France and Germany and other countries. It was suppressed for a long time because there was fear that the lawyers might become a countervailing power to the powers of the state. And the state was hiring the lawyers, but not supporting a private, independent legal profession. In late financialized capitalism, the law firms have become agents of capital. And I think it goes both ways. So corporations sometimes have general counsel. They typically have a series of law firms with whom they operate on and negotiate responses to particular problems as they arise. So they're in contact daily, what to do and how to package certain things. So I had an interesting conversation once with a finance guy who's actually depicted in the movie The Big Short, if you watched it. It's the main character, and Mike Eisner. And he contacted me about the Code of Capital, and he said, "Oh, you're overestimating the role of lawyers. It's us. We do everything." And I said, "Well, but what can you do without the lawyers? You can have a great idea how you would like to have a financial asset to be now traded. You create sort of, in a team effort, you create a new kind of a derivative. It does not fly unless it's enforceable. So there is, I think, a symbiosis of the two. It's difficult to say who comes first. In the large law firms, you have basically expertise from tax to financial regulation to competition law too, and that typically in multiple jurisdictions, and they put their heads together and create the package that you need. I just want to also say words about the civil rights lawyers. Paul Weiss was one of the leading law firms for civil rights litigation, lots of pro bono work that went into civil rights. It was the first law firm in the United States that caved in to Trump's demand to volunteer to give him $40 million worth of pro bono work for his pet projects, lest the company would face an executive order that banned it from federal buildings. Now, several of the smaller law firms sued, and they won preliminary injunctions. They won. This was totally illegal, but the top law firms in the United States, one after the other, caved in and gave Trump basically a war chest of almost $1 billion. That tells you more about the lawyers than anything else. And what I hear internally from people who know people who work there, the wife, the husband, or something of colleagues that I have, or talk to lawyers directly, it's the transactional lawyers who wanted to cave in, not the litigators. The litigators would have sued, but the transactional lawyers are the rainmakers. They bring in the big transactions, and they were afraid that they would lose their clients. I can only hope that they lose their best lawyers, the next generation of lawyers. There are Excel sheets circulating amongst my law students and at other schools as well. They're trying not to go to these kind of firms, and some people have left, and some clients have pulled their work as well. But it's a complicated, and I think you alluded to this, a complicated relation between the two. Revolution as a challenge, as I said, I don't think this can work. I think revolutions are almost disappointing in their short-term effect when you look at it. Even Lenin had to go back to new economic policy after people were starving in the countryside when he was trying to collectivize. It took the brute force of a Stalin to transform the system from above, a kind of transformation that I would not subscribe to, of course. I think resistance is important, but also resistance has to have a legal element to it. Let me give you one example. Joanna Kuciak, who is a sociologist teaching at Cambridge, UK, but she's also an activist in Berlin, Germany, originally from Poland, on the transformation of housing. So in Berlin, the social democratic government sold the social housing stock, which was substantial, to private real estate investors because they had some budgetary issues in the early 2000s. Then these investors found every loophole in the law to increase wages, although in Germany there's still a lot of wage control and protection of tenants, but they used, basically they were saying they were making green innovations at marginal levels and then increased rent prices. So she, amongst others, started a referendum in Berlin And they're also mobilizing a provision in the German constitution that has never ever been used, but is still good law, it's still on the books, which is Article 15 of the German constitution about socialization. You can socialize resources under German law, and nobody has been able to make the case that this is not legal. And so Joanna Kuzia calls this trespassing on the law. I call this legal arbitrage for the capitalists, but it's a kind of resistance that is passive resistance, but also tries to mobilize the creativity, the creative potential of creating legal rights and defending legal rights, because it just gives you more heft. You have just a much better argument if you can say this is actually, that is what we can do in law and by law. And they're doing a second referendum that hopefully will change the law in Berlin as well. Liberalism preceded democracy, yes, too, and the tension between the two are also there. There's so many different definitions of liberalism, it's hard to count. Absolutely correct. I think I said enough about lawyers. And again, sort of CEOs and legal experts, there's a mix of in-house, outside legal advice. One thing that I find deeply troubling, there are some lawyers in New York and London now that are demanding to be paid like an investment banker. So we used to have control of lawyers' fees in many continental countries. In the US, they were the first to start to work on billable hours. So how many hours you clock for your clients that will have to be paid, or contingency fees if you win the case. You get a big share in the outcome of a case, which is not legal in many jurisdictions here. They're now basically pushing for a cut in the profits that their clients are making, becoming investment bankers, and I think that's reflected also in the story I told you about Paul Weiss and the other firms.
Thank you. I forgot to ask you, please introduce yourself before asking. Okay, 1, 2, 3 questions, yeah, to the back.
Hi, I'm Andrea Nosko with Pilnet, and I really appreciate your talk. I want to ask about what I'm sort of seeing, a shift for the system that more resembles feudalism. So I wonder, how do you see the viability of capitalism and the capitalist law in a system, because of the concentration that resembles much more of a feudal one than a democratic?
Okay, Ina Malnikovska, CEU Vienna. I'm political economist, and so I appreciate a lot these legal insights, and I wanted to follow up on the notion of exit, which rather also reflects mobility or immobility of law. And it seems to me that the part of the problem that you describe is about mobility of private law, visualized through this international institutional arbitrage that you talked about, while public law is largely caught in the national borders. So I wonder, what kind of solutions do you think is feasible? Is it about the strengthening of national public law, or is it about going into with public law at the international dimension and initiating a kind of international public law there? And the other kind of part of the question is, what do you think? So we largely described this problem in terms of legal issues, a kind of incompatibility of these public and legal law institutions and structures, but it's increasingly becoming the matter of security, yes? So this capital, it's not only a kind of coming from and engaging with liberal governments, but it's increasingly the tools of illiberal governments to be used against a kind of liberal governments in jurisdictions in which this capital from illiberal countries can come into. Yes, so kind of how do you see this new layer of capitalist law from illiberal countries being a threat? Is it helpful to solve the problem or not? So, thanks.
Okay, thank you. Laszlo, please.
Thank you. We are in Hungary, the country of Polanyi, so we believe in movements, counter-movements, replies to these things. And the lawyers played several times very important role in counter-movements. I mean, the progressive era lawyers of antitrust were positive, or the New Deal era lawyers, constitution lawyers, and also regulators played a very important role. Krizsan wrote about rights revolution for the 30s, and then actually Krizsan became the regulation tsar of Obama in the 90s, or no, later. What went wrong there? Why this movement? He was, for example, talking about fight against the return of the Lochner era, when regulation or property becomes basically a pre-political, gets a pre-political status, gets out of even any regulation. So what went wrong? What do you think?
Would you like to respond?
Thank you. So feudalism, and I think this goes also to the question about illiberal orders. Yes, it's feudalistic. I agree with that. I actually have a wonderful quote in the Code of Capital by Bernard Rudden, who was a legal historian at Oxford. He also studied Soviet law. And he basically said the legal institutions that govern our financial capitalist system are the same, and they were created hundreds of years ago under the order of feudalism. So our property rights regime is feudalist, essentially, and today the same legal structures move not a piece of land or rights to land, it's never the land as such that moves, right? It's rights to lands that move, but they move funds across oceans by the click of a mouse pad. So he was writing in 1994 or so. That was actually also one of my motivations for the book, because I think the legal structures, together with their portability, that's also your question, is fundamental to recreate our system as a feudalistic system that is controlled by private actors who have access to lawyers that allow them to pick and choose from different legal orders, the ones that best protect their rights against the world. And they can invoke state power, and if states come against them to rein them in, then today they can also use the framework of state-investor dispute settlement under the bilateral investment treaties and other little games to protect their powers. So we have completely missed out on the opportunity to rein in private power. We have cherished and celebrated private power because so much money was made, and we ourselves did not really realize that this power actually comes from our social resource, the legal system, because without which it would not have been possible. So I would also say that capital is agnostic about the political regime. It partners with the political regime that gives it what it wants. And many countries have caved in, including democracies. You know, you can name the politicians, Angela Merkel and so many others who said, Obama, there is no alternative. This is the system that we have. And so you're basically already giving them the comparative advantage that they have, because they use the law that is there to code their particular interests with the help of their lawyers in a particular way that makes it very hard for states to come back and take it back again, in part because it is mobile, right? So you talk about the portability of the law. We created this through changes in our conflict of law rules. You don't have to do this. You could also change it back. It's of course hard when you have enshrined this entire regime in European regulations, because it's very hard to actually change something that happens at the international level. It's relatively easier to do this at the domestic level. But nobody dictates to you as such necessarily how you structure your conflict of law rules, which is basically saying, under what conditions shall my domestic law of this territorial state apply? And so, for example, the typical rule was, well, contracts you can pick and choose, we're not so worried, but property rights, every asset that you can find on my territory will be governed by my law. What do you do with financial assets? They don't have a physical location. So lawyers got together in The Hague, they created a new framework for conflict of law rules to deal with financial assets, and basically said it's portable, you can choose how you want to do this. So we've been basically down a rabbit hole of working to advance private autonomy in the name of liberal markets and the idea of neoliberalism that the markets are best left to their own devices and empowered by taking the states out of the equation of how to protect their laws. I think if we want to go back, the more effective strategy is to do it at the national level. I don't think we're currently in an international moment where we do treaties and can have agreement by enough states to do things differently. The beauty is that if relatively important states in the international economic order pull out and do things differently, things might change. So there is a paradox here as well. You know, maybe Trump is going to break down our international trading and investment order. So I can't exclude this with his tariffs, but he's breaking down other orders as well with the bombing right now. But he's basically taking the sledgehammer to the international trading regime. And maybe this will accelerate a process that was needed anyhow. The key for me, though, is where are the people who are now mobilizing for the post-Trump order to create something where we could actually benefit from different goods that we want to trade. We don't all want to go back to autarky, I think, but so create a different regime, and one should think about this, because I think the hammer is just the first step. The next step has to do the recreation. In Europe, it's always more complicated, because in Europe, once we have harmonized, it becomes petrified. It's very difficult to change these rules again. On the other hand, I think the European Treaty also gives you lots of inroads, subsidiarity principle, to change some of the rules, I think, and to have a bit more flexibility here. Laszlo, on the movements and counter-movements, the Polanyian point, yes, lawyers have very often been at the forefront of civil rights movements, also the New Deal. People in working for government have basically tried to mobilize amendments in the US Constitution to fight for workers' rights. Because what happened again in the private sector, there's a wonderful quote by a justice in the 1930s, Justice Black on the Supreme Court, who says the 14th Amendment was created to protect the formerly enslaved and their property rights by allowing them to go to the US federal district courts, because in their own states they probably would not have good protection under the state laws. And then he says in 1930, that's about 50 years after this 14th Amendment had been enacted, the only 0.5% of all the cases that have been brought to the Supreme Court were about black people. More than 50% were about corporations who used the little word person in the amendment to say we're persons too, and it works for us, in order to curtail the regulatory power of the states within which they operated. So, you know, it's a chicken. It's not a chicken egg. It's actually it's a race, and it's a race with very different resources, because the private actors know exactly what they want. They have different litigation, regulatory, lobbying strategies. They can also move their assets and go elsewhere if we allow it in principle. And so I think that has put us completely on the back foot now. It's very difficult to roll back a system that's now so deeply entrenched with legal rights and protected with, as I said before, investor-state dispute settlement against any attempt by a state to curtail this and step back, because they will immediately be threatened with a $100 million lawsuit. Whether they win or not is a different question, but many states already today don't do legislative programs in fear of the backlash that they might be facing from these investment treaties. They were invented in 1994 with a NAFTA. We've had 3,000, some countries have pulled out. We have now less than 3,000 of these treaties. So there are ways to get out of it, but I think we have to get out of this. But I think we've gone wrong in sort of in a way. Once the socialist world was gone, the big antidote, the big anti-utopia to capitalism had collapsed. There was no other vision there today. To this day, there's no other vision, and I think that curtails our imagination for how we could also use our legal rules in a very different manner.
Okay, I take the opportunity for asking two questions myself. You talk about that unequal race against kind of inventing regulations, subverting regulations, renewing them, etc. Andrea, in her introductory remarks, talked about kind of that streak of kind of hyper-wealthy, philanthropic individuals and foundations who try to do good. And so my question would be, if they would pour their money into hiring lawyers to say no to capital, as you say, as you advise us to do, and to strengthen state capacity to tax, to control, to supervise, would that make a difference? And another question is, in the recent time, I think fascinated by these individuals at the top, Elon Musk and others. We have been talking a lot about oligarchs, about hyper-rich individuals, and forgetting a bit about forgetting a bit about our previous preoccupations with corporations. Kind of 50 years ago, it was all about big corporations dominating everything. Are we looking at the wrong places? Are we kind of making a mistake with our personalization of these critiques? But still, there may be more questions. So please, yeah, Alvaro, please.
Hello. Hello, Alvaro Morcillo. I'm a research affiliate here at the Democracy Institute. I very much like your argument, but I would like to, because I like it, I would like you to be a bit more nuanced. Because I guess there are very differences regarding your argument if we look at the US and if we look at Europe. And there are also probably differences depending on the economic sectors. And the story is also in its origins different. If we compare continental law and common law, with the relation of the legal scholars in continental Europe, Polonia, to capitalism was a different one that the lawyers doing the dirty work for financial capitalists in London. And I suppose that the present is also different. So I would like you to tell us where the power of lawyers as servants of capitalism is more pronounced geographically, but also in terms of the economic sectors. Obviously, this works very well in finance, but maybe it doesn't work that well in other sectors. And maybe the places where it doesn't work well are the places where a counter movement could come from, where more idealist legal scholars, lawyers could have more leeway to improve modern capitalism.
Okay, thank you. Let's take one other question and then get back.
I already have the microphone here, if you don't mind. The mic came to me already. József Slezák, Central European University. I have actually two questions, but combined they are not more complex than some of the previous ones. So I would like to bring into our discussion the term varieties of capitalism. And I would be very much interested in your opinion, taking the example of Nordic countries, for example, in Europe. How do you see them, their way of exercising capitalism? So they tax all kinds of capital income and try to turn it into social assets, like through education or healthcare systems. So are your findings relevant also in this context to the same extent as in the neoliberal context? And then secondly, the European Union has started to introduce a series of policy measures whereby they aim to involve citizens in policy making at a higher level. And I was wondering whether you follow the relevant developments at the EU level, and do you think the EU has made a good start here also towards what you envision as the necessary changes? Or do you see this maybe more critically? Thank you.
Thank you. I would say let's make that the last round of questions. So if there are one or two more, then we can. Okay, there are two more in the back, please, and then. Yeah.
Okay, thanks very much, Max Steyr, Communist University. I was particularly fascinated by this public lawyer, private lawyer divide line in your talk, and maybe the blindness of public lawyers to the role of private power. But then also there is the fact that many of these cases are decided ultimately by judges. And I wonder to what extent this public-private lawyer divide translates into adjudicative practice. For instance, when it comes to the background of the judges being more, let's say, private lawyers by training or by previous care or public lawyers. Of course, it's a very broad question, differences between systems, but I would be interested if you could comment on that, because it would seem that maybe even the public lawyers who become judges are maybe not resilient enough to resist some of these current trends. Thanks a lot.
Thank you. If we can just 2 rows further in the middle. Yeah. This here in the middle of the mic. Yeah.
Thank you. I'm George Sabo, now a pensioner, so one of the persons who is actually feeling the impoverishment you were talking about at the very beginning of your speech. But my question would be regarding, I heard that you are also an expert on Chinese law. How do you see the incorporation in this Western type of capitalist law within China? What's the role of these new ways of capitalism being built in that part of the world? And a related question is that we see also in China a rather excessive wealth concentration. Is there a limit to the concentration when the system will become counterproductive to itself and will not enable the basic aims which were laid out previously? Thank you.
No shortage of really big questions. You have 6 minutes or 7.
I'll try. Yes, so a more nuanced approach, thinking about not mostly US, maybe not even just US and Europe, but think about how different systems respond to this. And here I fault myself. I pride myself to being a comparative lawyer, and I got my legal training before I taught in the United States, and I did study Soviet and Chinese law in London, so I like to look broadly. I think for these capitalism projects, I went to the heartland of capitalism and then looked out how it has affected other legal regimes as well. Because in an increasingly integrated legal order, so I would say the financial market integration was made possible by legal integration. And so I'm looking basically about tracing then where do these legal structures come from, how they're being created. And in that sense, and this goes also to the question about the varieties of capitalism, there's a hegemony of common law, of English and New York law in particular. So it's not Scottish civil law, it's not the UK as such, it's the English common law, because the common law is so much more malleable. It does have this very strong inbuilt ideas about private rights that can be enforced in a court of law. Also, and this goes to the question of lawyers, in the common law jurisdictions, you become a judge only after you have practiced law for many decades. So you're already a private lawyer and have done all the transactions once you hit the bench. That has a major advantage because these lawyers at least understand the transactions before them. In the international legal discourse, there's actually a great fear that some of the most complex transactions involving financial derivatives that are based on trust structures that are invented in London or New York will not be understood by a civil law lawyer who starts becoming a judge right after law school and basically has never taken a financial law class, if in doubt. There's a huge difference in the way we train our lawyers and in the way they practice before they become judges. Of course, this is also changing. In the US, we have many more highly politicized judges. I'm sure you've heard about this under Trump, and so that's a problem. I would also say that in the most civil law countries, you have different courts for different legal issues. You have public law courts going all the way up to the Supreme Public Law or Administrative Law Court. You have civil law courts, you have criminal law courts, and each of them is highly specialized. If there are major conflicts amongst them, then the top courts can resolve the issue, or if it becomes constitutional, you go to the Constitutional Court. So they're parallel court systems. In both the US and England, it's basically one integrated court system, which is very much dominated by private litigants. The Department of Justice, if it wants to bring an antitrust case, also goes through the judiciary very often and has to mobilize the lawyers on its side. And I wouldn't say that this is not possible. There are lots of lawyers and judges right now who are standing up to fundamental principles of the Constitution and have done so in other contexts. But I think there is, of course, a cognitive bias built into lawyers who have worked in private practice before they go to the bench, when they see the cases before them. And I think that's another structural feature, an important it's a variety on legal systems that is not captured by the varieties of capitalism. I think we really should do much more comparative civil procedure, organization of the courts and organization of the legal profession to really understand the differences between these firms. The varieties of capitalist literature is very much focused on firms, on business organizations, less so on these structures, and I think this should be done. On the Nordic countries, I think, yes, they are still able to make a different trade-off. I would say, however, that also a country like Sweden, you have the Wallenstein family, it owns a lot of real estate, but a lot of shares are also being traded, and they have also a lot of international investors who are buying and selling these shares. So it has become more hybrid. I think it's still better protected politically from the onslaught of capitalism. But there also Musk has this big battle over the Tesla mechanics. He doesn't have production in Sweden, but the mechanics walked out at some point because he didn't want to sign a union contract. And he said, I don't do union contracts. I do individualized contracts with individualized employees, and I give them bonuses if they are doing well. But I'm not signing a collective contract. And so the mechanics worked out and for over a year basically striked, which I found so interesting culturally. And it tells you also what the mechanism are for capitalism, right? The mechanism for capitalism is we do a bargain. And yes, I give you a little bit more. It's like an individualized bargain, but you don't want to be captured. You don't want to face a collective force on the other side. And since everybody else is so much smaller, you have to organize on the other side. And if then you don't have good protection in courts, in the US, antitrust law has been used to crash the unions. So, talking about lawfare, the weaponization of law against others, it's tremendous. And I think that's where pushback would have to come from beyond my wonderful neo-Brandeisian colleagues on my faculty, Lina Khan and Tim Wu. I think sort of smallness and this stuff are important, but I think we also need much more. We need much more collective action in principle. On Chinese law, so I wouldn't call myself an expert on Chinese law. I studied in 88, 89, which is kind of some time ago. But I've been following the events in China, at least from afar, and have sometimes co-authored work with people who speak Chinese and are closer to the system. So I think China is a really interesting example because it has tried to combine different modes of state control with increasing capitalist freedoms, but always with the inside controlled structures. And has done this differently for different aspects of the law, but I think the ultimate principle is that if not the state, the Communist Party still calls the shot. And if Alibaba wants to go public and they feel that a huge financial behemoth might be created if they went public and now had like a dispersed ownership structure with lots of institutional investors from around the world, they call off the IPO. They did call off the IPO for Alibaba, one of the, like an eBay-like platform. So state dominance is, a state/Communist Party, I think they go together, is still a huge principle in China. And they use it even if it produces short-term harm, right? They're not subject to elections, so they can impose harm on the population if they think that something might actually erode their power. I think it's a power game, a different one. It's a Communist Party that will want to be in power for much longer and will use the state's capacities to make that possible. But I would say in a highly ingenuitive way. If you think about the Silk Road projects, and if you think about how they're trying to also win over countries in the international realm, it's actually quite interesting. So then finally, it's basically the same question that Marx always asks, is sort of the internal contradictions of capitalism, wouldn't it give in to this at some level, right? You basically ask, it becomes counterproductive to itself, and it has. When you look at just statistics, medium income household, the median income of households has stagnated since the 1970s in the United States, and similar stories can be told in Europe as well. The rich become richer, the others become poorer, certainly do not improve. We have populism. We can't deal with some of our most important challenges like climate change. The system is just not working, right? What I find remarkable, though, is that in times of financial crisis, we always tend to mobilize enormous social resources to put the system back on its feet. Precisely because we do not have a vision of what an alternative would look like, we're fixing the system. We did this in 2007, 2008. We actually demonstrated in the COVID crisis that the state could do much more. It doesn't have to bail out the banks, it can also bail out the households. We did this, most countries did this to more or lesser degrees in the COVID crisis. There is state capacity there, but the ability and willingness of state actors to use it has been diminished. I think we have to come back to this democratic state capacity, I would add.
Thanks a lot. I don't think we can call that an optimistic note. It's one of the ironies probably, or expressive of our willingness to debate contradictions, that we will be moving on from a keynote speech and a discussion based on the legal foundations of capitalism to a panel debating illegal foundations of private wealth. But we will have a coffee break, half an hour. We will be gathering sharp at past here. Coffee is upstairs in the atrium. And Katharina, many thanks for very nice introductory session.